Of the 385 companies writing homeowners insurance in Louisiana, more than 99%, according to the state insurance department, have agreed to give their customers an extension to settle their hurricane-related claims.
But could waiting until after August 29th of this year create a significant disadvantage for homeowners trying to get more money? Joining us now to tell us why he thinks so is attorney John Houghtaling. And we appreciate you joining us. You have a very deep concern that this, on the surface, looks good and gives people extra time. Jim Donnellan has been fighting for it. Many have been fighting for it. But there's a downside.
There is. I think the insurance commissioner has done a fabulous job in trying to rally the insurance companies to force them to do this. But the problem is that by waiting, you may still have a claim against your insurance company, but claims against other parties, which may be necessary to adjudicate your claim, will be gone. And that is very, very significant.
Give us specifics.
Well, for example, the defenses that the insurance companies are coming up with, they have two main defenses. The first is, well, you're not covered for this flood. I know you thought you had hurricane coverage, but you have a flood exclusion. And your insurance agent should have explained that to you. Or you don't have enough limits. Well,
so you sue your insurance agent?
You need to have your insurance agent there in the courtroom answering that defense, because it may be that your policy does cover the things that your insurance company is saying it does not. There may be many policies out there, in my estimation about a third, that have what are called hurricane endorsements, which will cover all of the damages. But the insurance companies are going to point to an empty chair after August 29th and say your insurance agent didn't tell you that these endorsements do not apply, and that is why we really need to have them. We need to have them there.
Why wouldn't he be there? I mean, if there's an extension, why wouldn't he also be affected by the extension?
You could, but what if, for example, the jury were to find, you know, the insurance company is right and the insurance agent was wrong and should have told the person? Well, the insurance agent has insurance for that, but if you wait past the deadline, your claim against the insurance agent is completely gone.
Okay, I'm still not clear though. I mean, if there's an extension to the claims, why couldn't you still bring that insurance agent in? I mean, the extension applies to him as well as the insurance company, right?
No, it'll apply just to the insurance company at the moment. It does not apply. It does not apply to the agents of those insurance companies. You have other agents that are out there selling insurance, telling you what you need, what you don't need, what your insurance company says, what your insurance policy says, and interpreting that insurance policy for the insured. And those insurance agents, if you wait past August 29th, you run the great risk that all of those claims against those agents are gone forever.
Because there's a one-year limitation on them?
On them. That's correct.
So their malpractice or whatever it is gone. You do not have access to that?
Yes. The moment you realize, or you may realize, that you may not have been insured, which for many people may have been the day after the storm, well, that you have a one-year prescriptive period or a one-year statute of limitations from that event. So everybody that waits after after August 29th, everyone that waits runs the risk that their agent, that they will not be able to recover.
Okay, now what about these two statutes that the legislature passed? That they're in court right now.
They're in court and they're being challenged. They're being challenged vigorously by the insurance companies that these policies, the statutes, first off, there's two main statutes. The first statute gives people 2 years to file a claim.
Right.
And that statute is being challenged by the minority of insurance companies. Allstate was one for a long time and may still be.
But if those statutes survive, would those agents then be liable for 2 years?
No, because the statutes are only applicable to the insurance policy, the policy themselves, or the holder of that policy, the insurer themselves. So the agents, your claims against the agents may be gone.
So the commissioner's order and these statutes don't apply to the insurance agents at all?
They do not apply to the insurance agents.
But since, I'm going to interrupt you. So let's say State Farm is your agent. You can't hit your agent, but you can still sue State Farm and let them worry about getting it from the agent.
Well, the laws are different now. Under the Foster regime, what you have is you have pure comparative fault. So if your insurance agent may be held 80% at fault for a situation, and if the insurance agent is not there, you cannot collect that against the insurer that's there. Okay, unless the insurance agent is considered to be the same party as the insurance company. And State Farm, as you know, it's not just, people think of State Farm as just one company. It's not. It's a variety of different companies which may or may not have the same contingent liability.
And you don't have the right to subpoena someone to appear in court?
You can subpoena them. You can subpoena them.
But you don't have access to their
But if you
funds,
wait,
yeah.
if you wait, and the jury says, you know, it's the agent's fault, and the jury says the agent should have told them, then if you wait past this deadline, you will have you potentially could have no recovery in that situation. Whereas if you do file, you have the agent in the room. You have that agent's insurance company also backing what he told you, so that if the jury were to say, well, it's not the policy may not apply, but the agent may have liability or not, or vice versa. You have both insurance companies there covering that situation.
All right. So your advice is to file a lawsuit before the 29th?
Absolutely file a lawsuit. The other major problem is if you wait past the 29th, you may not have the ability to choose where you're going to fight. And that, for some people, is a very significant issue. People in New Orleans may have the right before the 29th to sue in state court in Orleans Parish. If they wait past the 29th, they may not be able to have that right. That right may be gone forever.
Where would you do the suit?
Well, the insurance company, if you don't agree with them, they can choose to sue you. And they can sue you in East Baton Rouge Parish. They can sue you in federal court. They could make you drive to East Baton Rouge Parish to fight a insurance policy which was written on your home in New Orleans. So that is a very, for venue and strategic purposes, a very significant thing which may be gone on the 29th.
If these insurance companies have agreed, for the most part, to give 2 years, why would that then, they would change the venue? So if a year and a half into it, okay, I'm going to sue my insurance company, I'm suing them, it would be in Orleans.
Because it may be a trick. Because the insurance companies are not saying that we won't sue you to determine whether you have insurance or not. The insurance companies are saying we will give you the right to sue us. But I can tell you, as a lawyer, I've had many clients. I had a client that was actually sued by an insurance company while he was in a coma. To get venue in a different parish. And so the insurance companies, once they find out that you're not agreeing with them, they could rush to a courthouse, which is more advantageous, in their view, may be more convenient for them versus for you. So if you don't, you have till the 29th to protect your rights. After that, they may be severely compromised.
Well, thank you for this information.